Hello, and welcome to Reject Modernity, Embrace Tradition, where we take you back to the good old days, just maybe not quite how you expect from our title. I am Megan Cox.
And I am Clayton Becker.
Now, Clayton, it's been a bit. I do want to say,
a little while. Frankly, we need to stop promising people that we'll be on some sort of regular schedule, because we say that every time. The vagaries of being an upper year graduate student just they preclude our ability to have a regular schedule at this point in our lives.
Definitely true, although at least part of this was not our fault. We did have a guest who was unable to.
It's true. We won't name the guest. It was not the guest's fault. It was their work's fault, wouldn't let them come on. We also did try to record an episode about Iran, and then I don't remember exactly what happened. I think my internet was on the fritz, and I had somewhere to be, and it just wasn't working. Anyway.
It was not in the cards. We're so sorry.
The audience does not care about any of this, but we feel as though we owed you a little bit of an explanation as to why we've been gone for a month. More than a month, frankly, at this point, right? But anyway, we'll be on as regular a schedule as we can, which you should take to mean sort of...
We're doing our best.
Yeah, exactly.
So should we talk about what we're going to talk about today?
Yes, Megan. Today we are going to talk about rejecting the Voting Rights Act and instead embracing Reconstruction 2.0, The Reckoning. This time it's personal. Megan had a better title for the episode, but I really wanted to say Reconstruction 2.0, The Reckoning. This time it's personal. And so that's the title of the episode.
I do want you all to know that I came up with rejecting the Voting Rights Act.
She did. She did come up with rejecting the Voting Rights Act. This is going to be much more about rejecting the Voting Rights Act than embracing Reconstruction 2.0, just because we're fucking annoyed right now and don't really have any solutions.
That's really true. That's really true. I will tell you, Clayton, as I went through the research on this, my blood pressure was very high.
Megan did text me and she was like, I'm not even through the syllabus and already my blood pressure is rising.
Yeah, for those who don't know,
the syllabus is the front matter basically of a Supreme Court decision. It's not the actual decision itself.
It's the summary. I was reading the abstract and I was stressed out.
Yeah. We should note here up at the front what we're not going to talk about. As we record this, this morning before we started recording this, the Virginia Supreme Court made a decision striking down the results of Virginia's referendum to redraw their congressional maps, which, let's be honest, were a Democratic gerrymander, right? It's too new. Neither of us have read the decision. But we want to foreground here that we understand the frustration. We are frustrated. Quite frankly, I would be content if the Virginia state government ignored the Supreme Court at this point, because what I have read about the decision is that it is ridiculous. But anyway, we're not going to talk about it at length. We want to acknowledge the frustration. We want to acknowledge that this happening so close to the decision, the Callais decision. And of course, while states in the rest of the South are gerrymandering in favor of Republicans, the impression that you're left with is Republicans don't have to play by the rules and Democrats do. So we want to acknowledge that, but we're not going to go into it in depth just because we haven't read the decision. We haven't we don't have any quality analysis for you on that.
Other than just our general frustration. We don't have any actual legal analysis for you on this one. I will also say that as I was writing the notes, I think initially it seemed like we were just going to wing this one and coast on our abilities. But I started realizing that I was going to need some notes, or I was just going to be heading off for the alfalfa. I needed some sort of structure. So is that an idiom with which you are not familiar?
Off for the alfalfa is not a phrase I have ever heard.
Okay. All right. Anyway, never mind. Is
this a regionalism? Is this something people said a decade before I was born? Why am I unfamiliar with this, Megan? Is it because
I really don't know, because we are from the same region? Don't know. Anyway, it really just might be something that my parents said. I I'm sure we will get a quality check on that when my mother inevitably listens to this episode.
Okay.
So anyway, I made us a little outline just because I thought I was going to be incoherent with rage if I didn't have something written down. But it is aggravating, I think, is the most polite way I can describe the Supreme Court's long-awaited decision in Louisiana v. Callais.
Yeah, you texted me while you were starting this. You were like, I can't believe that I am semi-voluntarily reading an Alito opinion. So we started really well, basically, with the aggravation factor.
He's just so smug. And we can talk about the fact that he is going to be smug, he's going to be too cute by half, and then get really offended when people don't like his opinion.
Whatever. Well, we can talk about that later. We can talk about John Roberts being like, these people have this mistaken opinion that we're political actors. I saw the article, I texted you about it, and I was like, even if you don't make decisions for political reasons, which come the fuck on, right? But even if you didn't make decisions for political reasons, you would still be a political actor, you absolute fucking idiot. Anyway.
Yeah. Anyway, okay.
I think I don't want a job in the legal profession, so I can call the Supreme Court, I can call the Chief Justice of the United States a fucking idiot. Anyway, let's talk about the Callais decision. Let's talk about the decisions that have preceded it.
Yes.
Let's talk about why the Voting Rights Act was necessary in the first place.
Yeah, for quite frankly, Clayton, you want to take us in the Wayback Machine and explain why we needed a Voting Rights Act in the first place?
Yeah, I'll take us in the Wayback Machine. There's something that I wanted to do in the episode with our voting rights friend, who will maybe be able to have on in the future. We aren't going to be able to do it here, because I need more than one other person in order to do the bit, basically. But the long story short is that the Voting Rights Act was passed in 1965, reauthorized several times, I think 1972, 1982, and 2006. Each time it was changed a little bit. In 2006, it was basically reauthorized as is. The reason behind why we have a Voting Rights Act is because prior to 1965, in a very real, actual physical way, Black voters in the southern United States were denied the right to vote solely on the basis of the fact that they were Black. The South used all sorts of techniques in order to stop this, stop Black voters from voting. They used poll taxes, they used literacy tests, they used grandfather clauses. This is where
Physical violence.
Yeah. This is where we get the phrase grandfathered in, right? Is the grandfather clause that, everyone will be subject to the poll tax or the literacy test or whatever, unless your grandfather was eligible to vote, right? Which made it so that basically all of the white people in the South were eligible to vote without having to pass any sort of literacy test, but Black people in the South had to pass said literacy test, right? And this is the bit that I wanted to do, and it's why I need more than one person, is I was going to have you and our guest take the first 10 questions of a Louisiana State literacy test from 1960.
Oh my God. So I actually did this in high school when I was a senior in high school. I think I've told you this story before. My teaching assistant, she was a student teacher. She gives us this we're just wrapping up our unit on the Constitution. So here's a test. She gives us, it was the Alabama literacy test, and then starts grading it out loud, giving the answers and saying what they are. And we're yelling at her because the answers are wrong.
Mm-hmm.
And we're so mad. And then she finishes it. She's like, just wait, just wait, just wait. She finishes it. She goes, yeah, that was a literacy test. And now you understand why this was so messed up.
Yeah, the Louisiana version is not about the Constitution or whatever, mm-hmm. right? It's it asks questions about make a small cross above the letter X, right? Draw a line through the whatever numbers, right? There's mm-hmm. a bunch of questions. It's the whole test is 30 questions long, and you were supposed mm-hmm. to have 10 minutes to do it. But mm-hmm. the way that the questions are written is they're written in such a way where no matter how you answer the question, you will get it marked wrong, or mm-hmm. you could conceivably have it marked wrong. Right? Mm-hmm. If you're supposed to draw a line and you draw a curve, they'll say you have to draw a straight line, right? If you draw the straight line, they'll say, well, you were supposed to draw a curve not going through any of the other letters, right? Mm-hmm. There are And these literacy tests, these poll taxes, these what are called tests or devices, right, exist throughout the South during this time period. And so in 1965, we passed the Voting Rights Act. It does a number of things. There are two really very important sections, and then one section that makes one of the other sections work. These sections are Section 2 and Section 5, and Section 4 makes Section 5 work. Very briefly, Section 2 of the Voting Rights Act, among other things, prohibits the use of this test or device. And in the 1982 reauthorization of the Voting Rights Act, adds in a requirement for majority minority districts, basically. And the rationale behind this is that in areas where you have racially polarized voting, and without these majority minority districts, white voters would vote as a block, as they mostly continue to do today in the South, in order to vote against Black folks' preferred candidates and deny them political representation. So that's the super Cliff Notes version of Section 2. Section 5 contained the pre-clearance requirement that certain what were called covered jurisdictions, mostly in the South, but also some in other parts of the country, had to check with the Justice Department, the Civil Rights Division of the Justice Department, before they changed any of their voting laws. This prevented many of these states from instituting discriminatory policies, either in intent or effect. One of the key ones that they were stopping, at least during the Obama era, were voter ID requirements. And so this brings us to really the first of the cases that start to slowly dismantle the Voting Rights Act as we know it, Shelby County v. Holder in 2013. I'll let Megan take this one as our resident legal expert.
Yeah. So I'm going to back us up on something else that was happening about the same time. And this was, I texted you, Clayton, I have a whole rant on this, and you said save it for the podcast.
I did.
So, there is this weird trajectory by which a bunch of people in Oregon getting denied unemployment benefits because they were fired for smoking peyote for religious reasons is the reason the Voting Rights Act gets dismantled. The courts are a mystery.
Weird. Yeah.
So in Smith versus Department of Employment Services, and this is an Oregon case, the U.S. Supreme Court ultimately upholds the employment department's decision not to grant unemployment benefits to these folks because they were fired for doing something that was generally illegal, even though they were doing it for religious purposes. Congress at this time has this really we got to protect religion kick going on, and it's actually kind of bipartisan. And so, using their authority to legislate to protect the rights of Americans under the 14th Amendment, they are implementing the Religious Freedom Restoration Act. Have you heard of this thing, RFRA? Okay. It basically changes the standard by which laws that impact religious observance are evaluated. The standard was previously that if the law was not for a discriminatory purpose, if it was being equally applied and it happened to impact religious practice, that law was permissible.
Mm-hmm.
RFRA purports to say that that's not the standard. And if a law impacts religious practice negatively, then that law can't stand under the First Amendment.
So sort of similar-ish, I guess, to the disparate impact standard, right?
I think so. I hope I'm restating this correctly. It really isn't going to wind up mattering all that much what RFRA does. Because at the end of the day, there's this case called Bernie versus Flores. Bernie is a city. It has zoning rules. And
my least favorite thing. Don't get me started. Fucking zoning rules.
Fucking zoning, including historical preservation. And I know you hate this, just the entire concept of zoning and historic preservation, etc. So this Catholic Church wants to expand. It is not big enough for its parish. The city says, we would love to let you do that, but your church is historic, and so we cannot let you change its footprint, basically. And the church sues. That goes all the way up to the Supreme Court, and the Supreme Court says, RFRA, that the church is suing under is actually not a permissible use of Congress's 14th Amendment legislation power. Congress can't say what rights are. The Supreme Court does. And the remedy offered has to be proportional and congruent to the right that is being infringed upon. So this was way too much by Congress, is what they're saying in Bernie versus Flores.
I am going to take slight issue with the court's determination that Congress doesn't get to decide what rights are, but perhaps not entirely important for the purposes of this discussion. Just know that I don't like it.
No. Yeah. I think there might be like a space for collaboration that might be actually better for our republic, but whatever. So that takes us to Shelby County versus Holder, in which the Supreme Court decides that Congress exceeds its authority to legislate under the 14th and 15th Amendments by requiring states to submit modifications to election law and procedure to the Federal Department of Justice ahead of the change. That is the preclearance. Preclearance is checking the modifications to the law to rule out if there is disparate impact or disparate intent on those covered jurisdictions. In places where discrimination against minority voters was historically the worst, it's important to note that there was an escape hatch from that preclearance.
There absolutely was. Yeah.
You could, if you were for a certain amount of time, never overturned by the DOJ in that preclearance process. If you kept not discriminating for a certain period of time, you could apply for preclearance and that preclearance would be granted. Would you like to guess what Shelby County couldn't do?
What couldn't Shelby County do, Megan?
They couldn't get preclearance because they had kept discriminating.
Fucking insane, right?
I honestly, go.
There are two things that I want to say about this. First, it's a little bit insane to me, honestly, kind of. I don't know, maybe it shouldn't be insane. Maybe I'm just misinterpreting what this is even supposed to be. It's insane to me that like the district court didn't bounce them for not having standing. Like,
okay, so I think it's really important that you understand that at this point in our nation's legal history, standing is fake.
Yeah, sure. But like,
it's like none of the standing rules I learned when I was in law school seem to apply anymore. So
yeah. Whatever. Anyway.
I'm sorry. Many things I learned in law school are no longer correct.
Yeah.
But speaking of when I was in law school, I think I told you, Clayton, that I did this. I had to argue a fake Supreme Court argument in my civil rights litigation class, and I picked this on the side of the government because I'm like, well, obviously these clowns are going to lose this case, and then it came down, and I was obviously very mad.
Anyway, first thing, standing is fake, I guess. Second thing, there's also an escape hatch that the Supreme Court could have taken here, which is preclearance applies to everyone, rather than preclearance applies to no one.
Yeah, so they have this idea. The Roberts Court has this idea at this point. And this is something that Sam Alito reiterates in this Callais decision, that racism has improved such that we don't need to be doing these things anymore. And I'm like, yeah, it's really great that we're not lynching people anymore. But the absolute scramble in every state that could to change their maps after this opinion came down, I think proves that might not actually be true.
And it's like the same fucking thing happened right after Shelby County, right? Like hours after the Shelby County decision came down, Republican states started passing voter ID laws, like the ones that were previously covered by Section 4B of the Voting Rights Act, like passed by the coverage formula. All of them, like, fucking did it immediately.
Yeah.
Right? Like,
yeah.
And I think the research is reasonably clear here that like voter ID laws do have a disparate impact. And in many states, they were intended to be discriminatory. Like North Carolina's previous iteration of its voter ID laws, for example, were struck down by appeals courts for, quote, targeting black voters with almost surgical precision. They just looked at the types of IDs that black voters were the least likely to have. And
hunting licenses, I think.
And they were like, those ones, those are fine. The IDs that black people are most likely to have, those ones, those are not fine. Like, that's literally what they did. That's like in the legislative record is what they did. And you're telling me this, like, I just, again, as you said, we needed some notes here because it's going to be aggravating. Like,
sputtering with rage. Yeah, absolutely.
So obvious that like the reason the discrimination wasn't happening is because of the fucking law you guys just struck down. Like,
yeah. I know. So, Supreme Court decides that this portion of the Voting Rights Act, specifically the coverage formula, is not proportional and congruent because the congressional record doesn't contain enough information explaining why it's still necessary to do these things.
This is another thing.
Which again, it's the umbrella in the rain, you know.
Well, this is another thing that I think is just absolutely fucking insane, which is that like Roberts writes in the majority opinion in Shelby County, like if Congress had started from scratch in 2006, it plainly could not have adopted the present coverage formula. And Ginsburg is like, but they didn't start in 2006, you jackass, right?
We're just going to invent some facts to make this work. So, like, we have to let the law lapse so that we can get the details we need to show that the law is still necessary is a pretty harmful setup and creates some pretty bad incentives.
It really does. It really does. And like not to, you know, bring us back too far, but back to like the bailout provision, right? Every qualified jurisdiction that had applied for bailout protection since the 2006 reauthorization of the law had been bailed out successfully. Every single qualified jurisdiction had been bailed out from under the coverage formula. The ones that were still there were there because they weren't eligible. Standing is fake.
Yeah.
Standing is fake.
Standing is fake. Standing is fake. Yeah. I mean, you can see a universe in which the court says that the law gives you a remedy already. And this is not the way to do it. But again, this is entirely, you know, people bring case after case after case, and finally one gets there and the court says, we will use this to achieve the ends which we already want to achieve. So, you know, anyway, but something interesting and also aggravating in this opinion, in the Shelby County versus Holder opinion, is that the court specifies that while sections 4 and 5 of the Voting Rights Act are no longer applicable, they're unconstitutional, you can't use them anymore, section 2 remains. Section 2 permits plaintiffs to bring suit against a jurisdiction for either intentionally or unintentionally limiting the ability of racial or ethnic minorities from fairly exercising their right to vote. That unintentionally part, that's the disparate impact standard, that was added later in one of those reauthorizations. As soon as people figured out that they could no longer say in the legislative record, we need to figure out a way to prevent minorities from voting. So this is one of those classic things that this court does where it's like, you've still got this other option. Why are you upset? You still have this other harder to pursue remedy. We're not getting rid of it. It's still there. We're not actually overturning it. They will do the exact same thing in Calais. Just to skip first.
And I think also important to note here, just like from a you know, legal history, I don't know exactly what the right term is here. Alito hates the disparate impact standard. He hates it. He thinks it shouldn't be a thing, and he has spent much of his legal career trying to get rid of it.
Yeah, I was thinking about this a little bit, because also in the context of, I don't know if you've read or are familiar with Richard Hanania's The Origin of Woke.
Yeah, I've heard the name. I don't read his stuff, but anyway.
Fellow UCLA poli-sci grad.
I don't think he actually graduated.
Did he not?
I don't think so.
Mastered out?
Maybe.
All right. So he makes a similar argument. He has a big problem with disparate impact. And so I've just been kind of rolling this around in my brain, like, why on earth conservatives have such a problem with this concept? And I mean, I think it might be the idea that, like, you have such a problem with the idea that you can be called racist, which is very, very bad for everybody, but for them, it's like, it's being called racist is worse than actually being racist. They have a problem with the idea that you can unintentionally do something that is racially discriminatory. They think that it has to have that animus. So structural racism is not something that they want to acknowledge or deal with, because that then kind of leads you back to the idea that you have to be accountable for something that you did unintentionally. This is like, have you ever run into somebody who's like horrendous at apologizing? You know, it's like, well, I'm sorry you felt that way, kind of thing. It's like, I didn't do it on purpose, but you're right, and we're going to fix it, is exactly the sort of response that the federal government has been engaging in with these disparate impact claims, and they hate it. And this was an opportunity to get rid of it.
Yeah. So, back to the present. Let's actually start talking about this decision. What exactly?
26 minutes in.
Yeah.
Love us. Okay. So in Calais, you got a group of white voters challenging a map that created 2 majority black districts in Louisiana where there had previously been 1. Do we want to go back over what a majority minority district is, or do you think we covered it sufficiently?
I think let's just clarify a little bit more here. Like, the number of majority minority districts in a state is relevant. It's about the size of the population and the plausibility of drawing those districts.
Yeah.
This is a broader problem, I think, with doing first past the post single member constituency elections in the first place. Mm-hmm. We're not going to dive into that here. But essentially, if, a state's population is 1/3 black or, 25% Hispanic or whatever, and those individuals live in an area that's relatively contiguous or relatively compact, it's possible for you to draw a district where that community gets to select the representative of their choosing, right? This is also, I think, importantly, one of the reasons why whenever Republicans bring up how gerrymandered New England is, it makes me laugh a little bit. Or, even before
the state borders were drawn in a way that's really inconvenient for them.
Yeah. Or when they used to make the same argument with regards to California before California did actually gerrymander in favor of the Democrats. It's in a lot of these states in the Northeast, in the West, sure, yeah, Republicans make up 1/3 of the population or whatever, right? But they're evenly distributed throughout the state, practically. You can't actually draw. It's basically impossible to draw a Republican seat in the state of Massachusetts, right?
Yeah. People try. It's very difficult to do.
You can, but it's Trump +1 in his best year, right? It's really difficult to do. And then Maine and New Hampshire are actually totally fair to Republicans. The second district in Maine, the second district in Maine is Trump +10 or something, or it was Trump +10 or Trump +9 in the 2024 election. And they've just run absolute dog shit candidates. Anyway, we're getting off topic here, but this is more or less what a majority minority district is. In states where you have a geographically concentrated minority population, you draw districts where that population is the majority population in that district, and that allows them to select their chosen a representative of their choosing.
Yeah, and it is just majority. So when I lived in Louisiana had 1 quote unquote majority minority district, and I lived in it. It was in New Orleans, unsurprisingly. And Phoebe's barking, sorry. And it doesn't guarantee that everyone who lives in that district is going to be of a certain community, but it just guarantees the opportunity to select a representative of their choosing.
Yeah, and again, just to once again clarify, the reason behind this is very simply that if you just drew, like, if it were like up to Louisiana Republicans to draw Louisiana's congressional districts, as we're seeing right now, basically, right? Or Tennessee's Republicans or Alabama's Republicans to draw congressional districts, they draw the lines in such a way as to break up the black voting population in those states, which essentially means that those residents of the state, those eligible voters, those citizens, cannot elect a representative of their choosing because the more populous white voters in any given district will outvote them. This is like the purpose of the majority minority district is saying, unless you draw these districts, this community in the state will not have any political representation.
Exactly. So Louisiana's population after the 2020 census is a third African American, and Louisiana has 6 seats in the House of Representatives. And it had one majority minority district. So the question then becomes, does Louisiana need a second majority minority district? At first, Louisiana does not add that second majority minority district. They just have the one, again, in New Orleans. Now, this was challenged by black voters under exactly what you would expect, Section 2 of the Voting Rights Act.
The thing that the Supreme Court said, hey, you still have this.
You still have this. You can still do it.
Yeah, exactly.
Yes, absolutely. So this map gets challenged. It goes up to the Fifth Circuit. The Supreme Court weighs in at one point. The Fifth Circuit ultimately sends it back to the Louisiana State Legislature saying, add a second majority minority district. They do that. I find it funny. There were 2 options. And the one that they did not choose was the one that would have split Speaker of the U.S. House of Representatives Mike Johnson's congressional district. So it seems as though that was a priority for the Republicans in the state legislature. Important to note that they have their priorities. Stick a pin in that. They have political priorities and interests. But they produced that 2 majority minority district map, and that is implemented for the upcoming elections. Then some white folks get mad. And Callais and a number of other folks challenge this new map under the 14th Amendment Equal Protection Clause, saying that the use of race in districting is an impermissible racial classification. I am mad at my fellow white people on this one.
I just like
there's
a whole broader argument here to be made about whether or not the 14th and 15th Amendments are actually supposed to be race neutral in the first place. I think that there is a very clear argument to be made that Congress's intent in passing those pieces of legislation in particular was to allow Congress to legislate in favor of Black Americans in order to bring them into the fold of citizenship. And the conservative majority on the Supreme Court seems content to pretend that actually they were intended to mean nothing of the sort.
Yeah, really, you want to like reanimate the corpse of Thaddeus Stevens and ask him if he thinks that white people should be able to use the Equal Protection Clause to protect their rights. I think he would ask, what are you talking about? Then he would also be very surprised that we went to the moon, but whatever. I think he would be astonished that this was an actual debate that we're having.
Yeah, I just like, again, there's this, I would say, like, frankly, kind of like insidious legacy left behind by like people badly interpreting the civil rights movement, that like equality was about like only formal legal equality and not about like actually trying to ameliorate or remediate like past harms, right? And there's just this, again, we don't have to get like too far down this rabbit hole here, but the purpose of the 14th Amendment is to make sure that Black voters do not have their voting rights, their rights abridged in the South. Like, there are other things that it does, other things that it was intended to do that we have in the legislative record. But there is absolutely no sense in the legislative record or in the text of the amendment itself that Congress guaranteeing Black political representation is not, as the amendment says, Congress having the power to enforce that article by appropriate legislation. It, to me, it like goes against the very clear plain text meaning of the amendment.
How could you possibly have implemented that amendment without using racial classification?
Right? Like,
whatever. We can't possibly get further down here. But so anyway, we have Samuel Alito writing the majority opinion.
Our favorite dude
says that under the Section 2 of the Voting Rights Act, the Louisiana state legislature was not actually required to add a second majority minority district. And because they were not required to add a second majority minority district, then the decision to do so is subjected to strict scrutiny and therefore fails because it's an impermissible use of racial classification to be districting on the basis of race in this case.
It's just so absolutely bizarre. Like, the reasoning is bizarre.
I was writing this and I'm like, this sounds ridiculous. Is it because I don't understand? And it's not. It's because the reasoning is not good.
Like, there's like 4 different things that are happening here, right? The first is that they are technically leaving Section 2 of the Voting Rights Act intact. Yes. The second thing is that they're saying the Voting Rights Act didn't actually require Louisiana to do the thing that the Fifth Circuit said Louisiana had to do, which is weird. Third, they're saying that, and this is part of the reasoning in the decision, that because like politics and like race are often coterminous in the South, and you couldn't prove that Black people voted differently from white people without relying on party, or like, sorry, after accounting for party.
Accounting for party, yeah.
Which is insane already.
I don't understand, and we'll talk about it. I'm gonna have to explain how this would even work.
And then fourth and finally, like, you have this like basically like prescription from the Supreme Court because of earlier decisions, specifically the Rucho v. Common Cause decision, that partisan gerrymandering is a non-justiciable political question. And so, like, you're leaving Section 2 intact, but saying, unless you can show racially polarized voting after accounting for politics, and then you have a previous decision that's like, if you gerrymander using partisanship, then we're not going to weigh in on it. Like, yeah. It's Samuel Alito very clearly drawing out a roadmap for Republican states to say, we're not drawing these districts because of race. We're just diluting Democratic voting power. That's fine.
Absolutely. So, I want to go back to Rucho and quickly connect some dots for folks because it's nuts. So in Rucho v. Common Cause, as you said, the Supreme Court said that partisan gerrymandering is non-justiciable. So the Supreme Court cannot strike down a map for being gerrymandered to favor Republicans or Democrats. That's not our thing. They're elected officials in the states responsible for this, and we can't intervene into their territory or their space. Samuel Alito, without specifically saying so, turns that non-justiciable thing that they can't have an opinion on into a legitimate state interest, and says that Republicans, specifically in Louisiana in this case, they can have the interest of preserving their power in the state. They can have the interest of preserving Mike Johnson's congressional seat and not engaging in any further challenge to him. They can do that. And that's fine. Additionally, Alito makes it a requirement under Jingles, which is the case that explains when you get that majority-minority district, makes it a requirement that challengers show that the political goals of the map drawers, whoever they may have been, could have been achieved in a more racially neutral way. So Alito puts it on the minority who is trying to protect their rights to go out and effectively find some black Republicans that can be stuck in a Republican district. And if they can't find them, the map is fine. And if they can find them, I have no idea what is stopping anyone from saying, oh yeah, let's use their map. That's great. And you still don't achieve the actual political goal of having a representative who actually represents the interest of a majority of the minority voters.
It's just so dumb. All of it's so dumb. Like, I need to, like, you know, like this fucking the scene from the second Knives Out movie where Benoit Blanc is just like, it's so dumb. And then Kate Hudson's character, is it Kate Hudson? Kate Hudson's character goes, it's so dumb, it's brilliant. And then he goes, no, you're just dumb. That's how I feel right now. Like,
that was a good Benoit Blanc, by the way. Good job, buddy.
Dumb. Like, it actually might be so dumb it's brilliant because, like, Republican states are racing to redraw congressional maps, including in places where primary voting has already started, which is
primary elections in Louisiana.
An additional level of insanity. But, like, it's
Jesus
just
Christ.
so dumb. Like, there isn't a way at the congressional level to demonstrate racially polarized voting after accounting for partisanship, because partisanship is what's doing the polarization. Like,
yes, honestly, yes. So this is something that I thought about, and it's just I was trying to figure out like what it was reminding me of. Republicans are doing everything they can to disenfranchise black voters. So black voters support Democrats. So Republicans say they're not limiting the power of black voters, they're limiting the power of Democrats. To paraphrase Thomas More in Utopia, you first make Democrats and then punish them. They are then saying this political polarization is the thing that they're trying to fight. It's not about race. It's not about race. I mean, sure, like being a Republican is not an immutable characteristic, but there is no reason why any person is obligated to, I mean, how is it any different than the white primaries? This is the only game in town will be the Republicans, and in order to be a Republican, you have to also embrace policies that disenfranchise you? I don't know.
I'm so annoyed. I knew this was going to happen.
Right?
When we said we were going to do this episode, but I'm so pissed about this.
Yes, yes. We're both turning red. For those of you who are not watching this on YouTube, we are both like impassioned here. Okay, so like, yeah. So Alito also does seem to be reading the disparate impact component out of Section 2, which Congress explicitly added in one of its several reauthorizations after the Supreme Court said that disparate impact wasn't in there. They said, oh, cool, okay, let's stick it in there. So they're still saying that there is some hypothetical Section 2 claim because they're pussies. Just
because they're cowards, right? Like, if you're gonna strike down Section 2, fucking strike down Section 2. Don't make the claim that you can now even theoretically plausibly bring under the section of the act. Like, don't make it. It's just insulting. You know what I mean?
Yes.
Like,
yes.
You're like, it's still there, but the only claim that you can prove is a completely unprovable claim. Right? Like, it's like, frankly, as you were saying, like, it's tautological at this point. It's like the reason why there is racially polarized voting in the South is because black people in the South are Democrats and white people in the South are Republicans. Like, I've talked about this before on various platforms, but to clarify for the audience just how much there is still, in fact, racially polarized voting in the South, If white people in the South, in like especially the Deep South, voted Republican only at the rates of white voters in still safe Republican states like Ohio or Indiana or Missouri, every single one of the states in the Deep South would be a safe Democratic state. Voters who are white in the South vote for Republican candidates at rates of like 80 to 90%.
80%. Yeah.
It's in like in certain areas, like in very like rural southern districts, it's like close to 90% of the electorate. It's crazy. Like the level of block voting, racial polarization in the South remains extraordinary, compared to the rest of the country. Like, I don't really know how to describe this any other way, right? Like, it just simply is the case that white voters in the South vote for Republican candidates by like Bashar al-Assad margins. It's crazy. It's crazy.
Yes.
And so by saying like you have to show racially polarized voting after accounting for partisanship is
what is that?
Right?
Like, I mean, genuinely, like, it's like, okay, so there's 2 Republican candidates and one supported by the black voters and one supported by the white voters. Is that what that actually looks like?
What this would actually look like is, and you couldn't prove this at the congressional level. You'd have to prove this at the local level, which I don't think the Supreme Court would consider a valid demonstration. Municipal politics are still quite racialized, like in terms of even within party. Right. So when you have, say, you know, a white city council member running for mayor and a black city council member running for mayor, even outside of the South, you'll often find situations where black voters in a city want one candidate, white voters in a city want another candidate. Right. It's not one-to-one, right? But it is very clearly racially polarized, especially in cities where you have mostly just white folks and black folks. This gets a little bit more complicated when you have like really large diverse cities like Los Angeles, for example, which is like 28% white, 13% black, 12% Asian, and like 45% Hispanic or whatever, right? Like, at that point, it gets really weird. But in big metropolitan areas where the 2 primary groups are white voters and black voters, you could demonstrate this by showing, like, in the Democratic primary, Democratic voters who are white want to support one candidate, Democratic voters who are black want to support another. That's how you would demonstrate racially polarized voting within party.
But across party, it's basically impossible.
Across party, it's basically impossible. It's basically impossible at the congressional level because the standard for racially polarized voting, like the thing that they look at, is in the general election. They're not looking for racially polarized voting in the primaries, or at least like you aren't under a situation where the Voting Rights Act is operable, because in those places, you have mostly black Democrats who are running for black seats, right? This isn't always the case, right? For example, Memphis's black majority district is represented by a white man, right?
We're going to talk about
by a white man for a very long time, and he continually, they really like him, right? But for the most part, right, you're considering racially polarized voting at the general election level. And the general election level is Republicans versus Democrats. It's just, it's tautological. It is designed to make it so that you can't actually effectively bring Section 2 claims. Like, you just can't do it.
Yep. So in the days since this decision came down, Louisiana canceled elections in which voting had already begun. And Tennessee, as we mentioned, has enacted a new map that eliminated that Democratic majority-minority district around Memphis. Now, Clayton, I've been to Memphis. I'm going there in a few weeks. It is an incredibly black city. I don't think I saw a white person that I didn't know before I got there the entire time I was there. So the idea that it gets, and this is the map, it has been split into 3 components and tacked onto 3 different congressional districts.
Yeah.
That is
extend way out into the like rural hinterlands of southwestern Tennessee.
Yep. Yeah. So that is the classic cracking strategy. And so Steve Cohen's district is no more.
Alabama, I think, is under like a consent decree or something where they can't change their districts until 2031 or something like that.
Okay, but the consent decree is with the Federal Department of Justice, is it not?
I don't know, maybe.
Well, we'll see then.
But like a plausible scenario here, more or less, is that Republicans draw out 12, I think it was, Democratic seats throughout the South. I think it's 12 actually, if you include Florida, which they were already going to do more gerrymandering. Again, in contravention of the state constitution, which explicitly prohibits partisan gerrymandering, but whatever. Again, Republicans don't have to play by the rules. But yeah, it's like not good, right? Like very not good. And I think, frankly, at the very, very top of Democrats' list, if they have a trifecta in 2029, early 2029, has to be like banning partisan gerrymandering. It absolutely has to be. That has to be like thing like 1A, like past the John Lewis Voting Rights Act with like supercharged provisions in it to like, frankly, I think the Republican states that are doing this need to be punished. Like,
yes. Do we want to take a break or do we want to head right into the solution?
I'm so mad. I'm feeling it. Okay.
Okay, because the problem, like, I mean, as I said before, the problem, according to conservative majority, is not the historical structural de jure racism baked into our country, but it's the act of using racial classification to fix it, and they're just wrong.
They are just wrong. They are, in fact, just wrong. Like, I'm teaching a class this quarter. I'm teaching a seminar about the history of housing discrimination in the United States. And like one of the takeaways that you have when you research this area is that it is functionally impossible to fix this problem without actively considering race. Because the reason that this problem exists was because for a century, we actively considered race and used it to discriminate, right? Like, you are not going to solve that problem where for decades, right, the federal government explicitly and implicitly made sure that Black families and other non-white families could not buy homes in any neighborhood, really, but specifically in white neighborhoods, right? And as a result, there's like all of these wealth disparities and we don't have time to go into it, right? But like, you're not going to solve that problem unless you are willing to explicitly favor Black families and help them crawl out from the hole that you've put them in, right?
Yes.
It's not going to happen.
Yes.
That's what the purpose of the Reconstruction Amendments is, right?
Yes.
Like, it is to allow the government to use race to ameliorate the harms of racial discrimination. You cannot do so otherwise. And this is the point where I'm going to use my time to call for second Uber Reconstruction, which is just that, like, I've been reading a lot about this stuff over the past like several months, if you can't tell. And I just like, it's insane how much of like the problems of the United States go back to just like utter chuddification of the South. Like, the fact that the South seems to have this belief that it should be allowed to do whatever it wants to Black people, whenever it wants to do it to them, and there's nobody who can say otherwise. Like, I've been reading Chandra Manning's book, What This Cruel War Was Over, which is like a history that looks at the letters and statements of soldiers fighting in the Civil War specifically, not just officers, but like enlisted men as well, right? Like, did they know what they were fighting about, right? And her answer is yes, absolutely they did. They knew they were fighting over slavery. And in particular, people in the North, Northern soldiers who did not start out wanting emancipation, went to the South, saw it, and then determined, actually, I will do whatever it takes to end this scourge, right? There's one sergeant whose name I can't remember, but the quote in Manning's book goes something along the lines of, I will fight until hell freezes over, and then I will cut the ice and fight on. Which is fucking banger of a quote, first of all.
So funny.
Right? A fucking banger of a quote. Awesome quote, right? But that is like kind of how I'm feeling about this right now. Like, unless you fully remove the control of Southern states from the of like the control of southern states to run their own elections. They are going to continue trying to do this, right? At a certain point, the rest of the country has to stand back and say, no, you can't treat black voters however you want. They are going to be allowed to exercise their rights. They are going to be brought into the fold as full citizens. And I don't care if you don't like it. You are going to have this imposed upon you because you can't fucking behave. Like, that's what's necessary.
Yes. I mean, it has been demonstrated over and over again. And I mean, honestly, I'd be surprised if there is anyone like this in our audience, but if you think racial discrimination is good, I'm not sure what I'm going to say to convince you. But if you think that racial discrimination is bad, but that doing things to resolve it is also bad, I think you might be salvageable. But it's not enough just to have an open election where everyone technically can vote. You also have to do things that make that equal across the board for people. You can't present something that makes it harder for people to effectuate their democratic rights and then be like, oh, well, they could still cast a ballot, so it's fine. Making somebody drive all the way across town to vote, eliminating early voting, eliminating mail-in voting.
A lower density of polling places in black neighborhoods, like all of this stuff, right? Like it remains, even under the Voting Rights Act, more difficult for black voters to vote than for white voters. Like, not even just in the South, but across the country, right? Like,
absolutely. Have I ever told you when I was living in Louisiana, I was voting in Louisiana, and our polling place was moved off campus with zero notice?
Told me about this. Yeah.
I was just like, oh, this is just a thing that happens. So it's so frustrating to see people who don't have an experience of that or don't have the context necessary to just kind of, whatever. No, like it happens so routinely that it can't possibly be anything but deliberate.
Yeah.
So if we can't have the gentle use of race as a remedy for disenfranchisement, I think then we can move on to the more aggressive strategy. As you said, that is, passing the John Lewis Voting Rights Act. That is apparently packing the Supreme Court and splitting up a couple of circuits.
There are a bunch of things I would like to do to the judiciary in this country. We could do like a whole separate episode. I texted you about the idea of doing a whole separate episode on this, but just to like tease it a little bit, perhaps, right? Like the Supreme Court has a very limited set of circumstances in which it has what's called original jurisdiction. The like things that the Supreme Court can hear without it having gone through another court first, right? I think it's section 2 of Article 3 also says that with regards to the things that the court has appellate jurisdiction, Congress can make exceptions. My preferred solution at this point is to strip the Supreme Court of its authority to hear anything except for the cases that are in its original jurisdiction. I also think that the Supreme Court should be dramatically expanded. The justices who decide to hear a case are not the justices who actually hear it. And, in particular, the Supreme Court justices lose their ability to select their own clerks.
Ooh, that's interesting. I like
These are like a few of the things I have been thinking about.
I like it. I like it a lot.
Especially because I think, let me just explain why the clerk thing is important, right? Like,
I get it. Yes, tell the folks.
The audience. Yeah. The Supreme Court clerkships are the most sought after position in the legal world, perhaps. With maybe the exception of like, I'm going to be senior partner of a big, firm in 30 years or whatever, right?
Yeah,
like,
you do the Supreme Court clerkship and first, then you're the partner.
And then you go in. Yes, exactly, right? And so, like, the people who become Supreme Court clerks, are the people who are like going to shape the jurisprudence of the country, shape like the legal frameworks of the country for the next, 40 years that they're working on average, right? Having Supreme Court justices have the authority to select their own clerks has a really, really, I think, corrosive influence on the legal system in the United States, not just because we have been, for the last 25 years or so, selecting partisans to be on the Supreme Court, but also because certain justices, Alito, Gorsuch, Kavanaugh, have chosen to select clerks that are very ideologically similar to themselves, right?
Yes.
And so they are elevating their ideologies to a, like, very important place in the legal sphere.
It also, not for nothing, serves as affirmative action for conservative law students.
Absolutely does. There's a whole thing here about, like, I don't, someone check me on this statistic because I have not independently verified it, but I was told in one of my undergraduate classes where we were talking about like judiciary stuff and all that, that if you are a conservative who goes to Yale Law in particular, which people who don't know law schools don't know this, but Yale Law is like actually way better than Harvard Law or Stanford Law.
It is the actual best.
It's the actual best law school in the country. But if you are a conservative who goes to Yale, your lifetime odds of becoming a federal judge are something like 1 in 7. That doesn't happen unless you are selecting on the basis of partisanship.
Yeah. Yeah.
There's
so the ratio of conservative to liberal lawyers and law students is so significant.
Lawyers as a whole are a very democratic constituency.
Yes,
like,
exactly.
There's a paper, I think it's Maya Sen and Justin Grimmer, maybe, The Politics of Selecting the Bench from the Bar, which basically looks at, like, here's the distribution of lawyers. Here's the distribution of, like, regular old judges. Here's the distribution of appellate court judges. And as you go up and up and up, you get this greater polarization. And there is no way to explain that unless you are selecting on the basis of partisanship. Like, if you were just randomly selecting,
to be a judge,
who could be a judge, then the distribution of judges, the distribution of appeals court judges would be the same as the distribution of attorneys, right? Even if you were selecting based on like just like a meritocracy, right? Unless you somehow believe that like conservative attorneys are inherently more meritorious than liberal ones, which maybe some conservatives do, but is not found in the data, right? Like, that would also produce a distribution that basically looks the same, right? Which is a single peaked distribution where attorneys are broadly to the left of the American public in terms of their ideological positioning. Instead, what you see is this dual peaked distribution where on one hand you get liberal judges and on one hand you get conservative judges. That doesn't happen unless you are selecting on the basis of political party, on the basis of ideology. But anyway, like, I think that there are a bunch of things we can do to the judiciary here, that we should do to the judiciary here, and then also the South needs to once again be brought to heel.
Apparently.
Like,
because I mean, we just keep seeing that it just keeps happening. And even if you want to accept, okay, this isn't about race. I know, but even if you want to accept that this isn't about race, I do think it should be noted that partisan gerrymandering and partisan polarization generally are also not great for democracy.
Yeah, I think, I don't remember exactly who I saw this from earlier today, but when I said sort of at the beginning of the episode, right, that like the Virginia legislature should ignore the state Supreme Court, this person's reasoning was more along the lines of like, if the impression that everyone is getting is that Republicans do not have to play by the rules and there is no political efficacy to voting, then people are more likely to turn to violence. And we're already seeing it. Like, we're already seeing a rise in politically motivated violence around the United States. And it is because people do not think that they are able to affect political outcomes through the democratic process, right?
Yes.
And if that becomes like sort of like known thing, right? That people think, well, voting doesn't matter. There's nothing that like, if Democrats come to believe, if some even small critical mass of Democratic voters come to believe that there is absolutely no way in which their votes will matter. Like, no matter how much the country disagrees with what a Republican president or a Republican Congress is doing, those voters will turn to political violence in order to get what they want. And it's the same thing for the Republicans, right? If you have the situation, again, this is why partisan gerrymandering is bad in general, right? Where Republican voters believe that no matter how unpopular a Democratic president is, no matter how unpopular a Democratic Congress is, nothing they can do through the standard democratic process will allow them to not have that government in place, then they will turn to violence. Like, that's how countries fall apart.
Yeah, I mean, I think that's the kind of like mental image that a lot of like the Northern Californian Republicans have, and I mean like far north, like way up there, Northern Republicans have about California. It's like, well, there's nothing we can do, and it's illegitimate, and it's not fair. And like, your problem is with your state's borders here. To be clear, there is no gerrymandering involved. But yes, as you continue to put people in these safer and safer districts, the minority voters, and by which I mean not necessarily racial minority, but the political minority voters, are going to continue to feel that disenfranchisement. And they need to feel as if there is some way that their voices can be heard. Additionally, it pushes the parties to the periphery by having the only thing they're worried about be a primary electorate, not a general electorate. If you're concerned about having two parties that are just way too separate to ever work together, what you want to avoid is partisan gerrymandering.
There's also a situation in which states that are gerrymandered for only one party and do not have any representatives of the other party face a situation where, in the event that, say, the Democrats hold Congress, the states of the South do not have anyone to advocate for their interests in that state, right? Like, it is important still that if, for example, Tennessee wants money to do something, right, that they have a Democratic representative to put money for Tennessee into the fucking bill. That's not going to happen if you have like a mono-party controlled state where that state has absolutely no say in what goes into a piece of legislation because they have no representatives in the party that controls Congress. Like, it's just bad all the way down. It's bad all the way down. And this is why we need to get rid of single member constituencies and institute a proportional system in the first place, but whatever. It's another episode. Have we done reject first past the post, embrace proportional representation?
Not. We should.
We should. We gotta look through our back catalog here, see if we've done something. Before the anger of the past 30 minutes transforms into me being exhausted and tired, which is surely what's about to happen to both of us.
No, we have a party tonight, man. Like, you're gonna need to rally.
Yeah, I actually do need a rally. I need to take like a 45-minute nap. I don't know. For those who, well, we should actually say what this party is for, ostensibly.
Just so the audience can get an idea of how nerdy our social circle actually is.
Yeah. This is definitely not just an excuse for these two boys to throw a party, but it is National Report Government Contractor Fraud Day, apparently, today. And so that is the party. It is the National Report Government Contractor Fraud Day party. Waste, fraud, and abuse, not on our tab. If you see something, say something, then party. Good vibes, zero tolerance. So that's the party that we have tonight.
Yeah.
But anyway, back to the discussion at hand. How should I put this delicately as a way to finish the episode? Like,
oh man, I called the Supreme Court pussies like half an hour ago. So
that's true. You did do that. Anyway. Okay. I'll leave our listeners with this after what, even with our structure, was a pretty freewheeling episode. There is no democratic future of the United States where one party can't lose. Regardless of who wins the gerrymandering wars, that is the road we are headed down. We seem to be headed down that road in much the same ways we head down other roads, with minority members of the United States feeling the hurt first, right? But this will not end here. This will not end with just the most vulnerable having their rights taken away, being disenfranchised, not having a voice in the political process. This will end unless we head it off at the pass and just ban both parties in this country from using this kind of tactic, with the United States ceasing to exist as a unified political entity. That's like truly what I think.
I honestly, I don't disagree with that. I think I don't know if it's indicative of just me and my algorithm or what, but that is, there's a lot of discussion of balkanization.
One, there's a sort of inescapable, like, what if kind of thing that I've been sort of feeling recently, especially as I read more stuff about the Civil War. I've just been on a Civil War kick recently, reading Chandra Manning's book, reading Cherno's biography of Grant, which I'm like 350 pages into. Like I read stuff, I read like a Lincoln biography or like a Lincoln something or other recently. Can't remember exactly what it was. But there's this like inescapable what if Lincoln hadn't died and Johnson hadn't stopped Reconstruction for 4 years before Grant took office and, you know, started to do actual Reconstruction, right? And, you know, the people may say, I think lots of people do say that treating the southern states differently is impermissible somehow, right? That like the federal government has no right to run roughshod over them. Republicans say this. I see your face, Megan, but people say this. My response would be, you lost the war. The federal government can do whatever it wants to you, frankly. The southern states are special in this regard. They rebelled against the government and lost. And they're lucky that Lincoln and Johnson and Grant didn't do more. But they have proven over the ensuing 175 years or so that they simply cannot be trusted to behave. And until we can de-Chudify the South, in the same way as, frankly, we had to denazify Germany, they should be treated as though they can't behave and as though they do not have the wherewithal to govern themselves. Because that's quite frankly what it seems like. That's all I got.
Until we do that.
Yeah, until we de-Chudify the South.
Until we adopt the Battle Hymn of the Republic as our national anthem, which we should, because it's a banger.
It's a fucking banger. As he died to make men holy, let us die to make men free.
Yes.
Banger.
Yes, exactly. Until we can do that. Until we pack the court, until we pass the John Lewis Voting Rights Act, until we do all of these things. I have been Megan Cox.
I have been Clayton Becker, and we will see you guys at some point in the future.